Surprise. Hand down judgment in Lloyd and Google LLC.
For the reasons given in the judgments we have handed down today, the appeal will be allowed and an order will be made granting Mr. Lloyd permission to serve these proceedings on Google outside the jurisdiction of this court. We have prepared a press summary to explain the judgment. Everybody listening should realize that the summary is not definitive. What is definitive is the judgments in the case. Nonetheless, I shall deal with the summary, read out the summary broadly this morning, just so as to enable those listening to understand what the court has done. The Court of Appeal in this case consisted of Dame Victoria Sharp, the President of the Queen's Bench Division, me and Lord Justice Davis. And the central question in the appeal was whether the claimant, Mr. Richard Lloyd, who is a champion of consumer protection, should be permitted to bring a representative action against Google, a corporation based in Delaware in the United States. And Mr. Lloyd made the claim on behalf of a class of more than 4 million Apple iPhone users. He alleged that Google secretly tracked some of their internet activity for commercial purposes between the 9th of August 2011 and the 15th of February 2012. And Mr. Lloyd alleges that Google was able to identify visits to any website displaying an advertisement from its vast advertising network, and to collect considerable amounts of information. It could tell the date and time of any visit to a given website, how long the user spent there, which pages were visited for how long, and what advertisements were viewed for how long. And in some cases, by means of the IP address of the browser, the user's approximate geographical location could also be identified. And over time, Google could and did collect information, it's alleged, as to the order in which and the frequency with which websites were visited. Mr. Lloyd alleges that this tracking and collating of what is known as browser-generated information, or BGI, enabled Google to obtain or deduce information relating not only to the user's internet surfing habits and location, but also about such diverse factors as their interests, race or ethnicity, social class, political or religious views or affiliations, age, health, gender, sexuality, and financial position. And it said that Google aggregated browser-generated information from browsers displaying sufficiently similar patterns, creating groups with labels such as football lovers or current affairs enthusiasts. Google's double-click service then offered these groups to subscribing advertisers, allowing them to choose the type of people to whom they wanted to direct their advertisements. The first instance judge, Mr. Justice Warby, had dismissed Mr. Lloyd's application for permission to serve Google outside the jurisdiction of this court in the United States of America, so preventing the claims getting underway. The Court of Appeal has reversed the judge's decision and given Mr. Lloyd the right to proceed with his representative proceedings against Google in the Media and Communication Courts here in London. The Court of Appeal decided 3 legal questions. First, that a claimant can recover damages for loss of control of their data under Section 13 of the Data Protection Act 1998 which implements Article 23.1 of the Data Protection Directive without proving pecuniary loss or damage, or distress, I should say. Secondly, that the members of the class that Mr. Lloyd seeks to represent did have the same interest as one another under Part 19.6(1) of the Civil Procedure Rules and were identifiable. And thirdly, that the judge ought to have exercised his discretion to allow the action to proceed as a representative action. And the appeal raised important issues that were not decided by the Court of Appeal in a previous case called Vedal Hall against Google. And although Vedal Hall was argued on the basis of analogous underlying facts, there was one critical difference. In that case, the individual claimants claimed damages for distress as a result of Google's breaches of the Data Protection Act. And in this case, Mr. Lloyd claims a uniform amount by way of damages on behalf of each person without seeking to prove any distinctive facts affecting any of those people, save that they did not consent to the abstraction of their data. The court relied on the decision in the phone hacking case of Gulati against MGN Limited to decide that if damages are available without proof of pecuniary loss or distress for the tort of misuse of private information, as was decided in Gulati, they should also be available for a non-trivial infringement of the Data Protection Act. That was because both claims are derived from the same fundamental right to data protection contained in Article 8 of the Charter of Fundamental Rights of the European Union, which provides that everyone has the right to the protection of personal data concerning him or her. The Court of Appeal rejected Google's main argument that both Article 23.1 of the Data Protection Directive and Section 13.1 of the Data Protection Act require proof of causation and consequential damage. The words in Section 13, which are an individual who suffers damage by reason of a breach is entitled to compensation, justify such an interpretation, the court decided, when read in the context of the directive and of Article 8 of the European Convention on Human Rights and Article 8 of the Charter, and having regard to the decision of the Court of Appeal in Gulati. Only by construing the legislation in that way could individuals be provided with an effective remedy for the infringement of such rights. The claim was an unusual use of the representative procedure, but the court held that it was permissible on the authorities. The claimants that Mr. Lloyd seeks to represent will all have had their browser-generated information, which is something of value, the court decided, taken by Google without their consent in the same circumstances during the same period, and were not seeking to rely on any personal circumstances affecting any individual claimant, whether distress or volume of data abstracted. The represented class were all victims of the same alleged wrong and had all sustained the same loss, namely loss of control over their browser-generated information. Mr. Lloyd's concession that he would not rely on any facts affecting any individual represented claimant had the effect of reducing the damages that could be claimed to the lowest common denominator. But it did not mean that the represented claimants did not have the same interest in the claim. It was impossible to imagine that Google could raise any defense to one represented claimant that did not apply to all others. So just once again to remind you, the summary that I've just read out is not the definitive judgment. The definitive judgment is to be found in the judgments of the court which I've handed down this morning, and those are to be relied upon as the decision itself. The order that the court will make is to allow the appeal, to give Mr. Lloyd permission to serve the proceedings on the respondent outside the jurisdiction, to order under CPR Part 19.61b that the claim be continued by the appellant as representative of other persons who have the same interest in the claim. Permission to appeal to the Supreme Court is refused, but provided that the respondent, Google, pursue an application for permission to appeal with due diligence, the proceedings shall be stayed until either the refusal by the Supreme Court of that application, or, if granted, until the determination of the appeal by the Supreme Court. And an agreed order as to costs has also been made. Thank you.
Right.